All right, let's get started with our top story. The Supreme Court's clean-up mission. Two different developments from the court today that could lead to an overhauling of our political system. The first, of course, relating to the CBI status report in the coal allocations case. Remember, the Supreme Court had called the CBI a caged parrot. Well, today the court tried to set that caged parrot free. Also, another critical order coming in from the court on weeding out criminals. The court declaring that no MP or MLA that has actually been convicted by any court can use the right of appeal to continue in either the Legislative Assembly or the Parliament. Let's bring you the details now. These are the specific points of that crucial Supreme Court order. MPs and MLAs cannot continue if convicted by a court. The sentence, of course, has to be 2 years or more. So one can assume that it relates to serious criminal charges that result in convictions. The Supreme Court, in a scathing observation, said that there should be no difference between a neta or a common man. The law has to be the same for them. And this is something that could change politics as we know it. But will political parties accept it? Think about this. If this law was in place today, if the Supreme Court order had come earlier, who could not have contested? Some of the most notorious names of politics. Mukhtar Ansari, who has continued to contest despite convictions. Om Prakash Chautala, currently in jail facing a conviction of 10 years. Well, he can't contest an election now. And Pappu Yadav. These are just three names that we have taken. But do remember that if political parties don't do something to actually fend off this order, then even prominent politicians could find their fate hanging in the balance as they move forward. Let's look at just one of those leaders. RJD chief Lalu Prasad Yadav. There you can see it. His fate actually hangs in the balance after this Supreme Court ruling, because remember, there's a crucial judgment awaited in the fodder scam. It may even come this month. And if it results in a conviction of 2 years or more for Lalu Prasad Yadav, he will have to give up his seat in Parliament. The other very, very critical development in the Supreme Court today relates, of course, to the coal allocations. Remember that the Supreme Court had called the CBI a caged parrot. Remember that this is a case that goes to the heart of whether the CBI can ever be liberated from its political masters, no matter which party they are in. Well, first, in an embarrassing development for the UPA, the centre has been asked by the court to bring all the paperwork relating to 164 coal allocations. Some of them, of course, pertain to the 1993 period as well, when the UPA was not in power. But this is a critical case because the Prime Minister held the coal portfolio between 2006 and 2009. The Supreme Court has demanded to know why the centre is not cooperating with the CBI. And they have said, why does the CBI need government permission to prosecute officers? Now, this goes, of course, to the heart of another controversy. The Attorney General has told NDTV that it's the government and not the CVC that should retain the sanction to prosecute officers, whereas the court today has said it can be the CVC, it doesn't have to be the government. So the court's clean-up mission will be focusing on that in the next few minutes. But first, time for a news break with my colleague Sunil Prabhu. Now, Sunil, in this particular development pertaining to the coal allocations, a couple of crucial things have happened. One, of course, that the Supreme Court has basically asked the centre to justify 164 coal allocations. But remember, this is the same court that had called the CBI a caged parrot. Today, it attempted to restore some of the autonomy to that process of the CBI conducting its investigations. And one of the crucial questions it raised was, why does the CBI need government permission to prosecute? Why does the CBI need government sanction? But the Attorney General is telling you that the government is still arguing that it's the government that must retain the right to grant a sanction before an officer is prosecuted. Doesn't this go directly against what the court wants?
That's right, Barka. In fact, there is been a difference of opinion. The Attorney General has held a classic opinion in terms of there has been a difference of opinion between the CVC, which the court had been wanting to be the supervising authority of the CBI. It has said very clearly that the CVC cannot be the deciding factor. The AG says it has to be the government. It is the government which has the inherent power to direct any kind of independent inquiry or direct inquiry of investigation for any joint secretary level officer and above. And that power remains with the central government. That, of course, today was given a go-by by the Supreme Court when they gave that observation saying that it's actually the CVC. But in reality, as I've explained, the opinion of the Attorney General in a matter between the CVC, where the CVC contested this entire issue with the Government of India. The Attorney General opined that clearly the central government is the deciding factor and not the CVC. The CVC can decide for matters for officers below the Joint Secretary level, but anybody above the Joint Secretary level, that is the big fish as we put it, they will be decided by the central government whether there can be a direct investigation or for that matter any direct inquiry by the Central Vigilance Commission or for that matter the CBI.
Well, thanks very much, Sunil, for that news break. So the Attorney General of the government continuing to maintain that the government must retain the right to give sanction before officers can be prosecuted. The Supreme Court thinking otherwise. Interestingly, even in that other important judgment coming in today where the Supreme Court has said that no MP or MLA facing a conviction of 2 years or more can be allowed to continue in their seat, the government affidavit had argued otherwise. Let's now get to the heart of our debate on the buck stops here tonight, the political punch on the court's cleanup mission. Joining us now live on the program, Abhishek Manu Singhvi, spokesperson and senior leader of the Congress Party. Ravi Shankar Prasad, senior leader, deputy leader of the BJP in the Rajya Sabha, also joining us. Also joining us, Prashant Bhushan, senior advocate and member of the Aam Aadmi Party. And we'll also be joined by Trilochan Shastri, who's done some sterling work with the Association for Democratic Reforms. Abhishek Singhvi, let me start with you and ask you to look at the big picture. What we are seeing as citizens today is two crucial orders that point in the same direction. Their attempts to clean up the political system. Whether it's the court saying that MPs and MLAs who face a conviction of 2 years plus should not be allowed to continue, or whether it's the court saying that why should the government have the right to grant a sanction before officers can be prosecuted? The CBI needs to be set free. This is the court basically taking a shovel and shoveling up the dirt in the political system and trying to throw it out. How embarrassed is the centre first by the developments in the Cole case?
Barkha, there is no question of embarrassed. Please see two facets. Now you're asking only about the sanction because I'm not talking of the disqualification.
Yeah.
A sanction was actually in origin a good idea for preventing vexatious, malicious prosecution of bureaucrats, which has become a totally bad idea because it is a refuge for the corrupt. As chairman of the parliamentary committee, we have a long chapter on it, and we had recommended very clearly in a detailed portion all sanctions, be it 197, be it section 19 of the Prevention of Corruption Act, or be it the single directive, all be abolished. However, and that is, I think, something which should go through as and when Parliament can have time, whether from disruptions or other kinds of fracas, to pass a law. But this should go through. That's my clear.
Why is your government's Attorney General arguing otherwise? Why is your government's Attorney General arguing otherwise?
1 minute, it's complete mix-up, Barkha.
All right, Abhishek Singhvi saying it's a complete misunderstanding. Go ahead, Mr. Singhvi. Yeah.
He has to, you see, so long as the provision stands, the Attorney General or the CBI Director, can he say, look, go ahead and prosecute Barkha Dutt without seeking a sanction, although the law stands. Now, one last point.
Yeah.
This is the manner in which law develops, and it's entirely possible, and I think it may be right for the Supreme Court to say, although the provision stands, and unless we, the Supreme Court, interpret it, you are bound to follow it. So we interpret it to mean that for court-monitored investigation, there shall be no requirement of sanction. The law progresses ahead. Now, today, both the sanction provisions stand. So, the AG and the CBI Director have no option but to seek that permission of the court. The court is entitled to say, we give a gloss, an interpretation, a nuance, which says that such sanctions will not operate where it's a court-monitored investigation for that narrow class of cases. And later on, I hope and trust, Parliament will find time to implement our recommendations collectively of 17 parties, of 13 parties, 32 members, that it is repealed.
Ravi Shankar Prasad, would you agree with Abhishek Singhvi's interpretation?
One sentence.
Okay,
Barkha.
Just one sentence.
These provisions have withstood Congress, non-Congress, BJP, non-BJP, Third Front, all governments for a pretty long time.